all persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Thank you. Good morning. We have 3 cases on the calendar this morning, and we're ready to call the first case, Gene Nelson versus United States. Counsel for Mr. Nelson.
Good morning. This is Richard Seligman for Gene Nelson. I'd like to reserve 3 to 5 minutes for rebuttal, please. This case involves essentially 2 issues. Did the trial court err in failing to suppress out-of-court and in-court identifications, and therefore violated due process by allowing impermissibly suggestive identification, which gave rise to irreparable misidentification, both in court and both out of court and in court. And secondly was the undercover officers show up identification of the suspect in both the out of court and in court identification so unreliable that reasonable jurors could not find beyond a reasonable doubt that the police ID'd the correct person. The facts of this case are pretty straightforward.
Mr. Seligman, can I jump in and ask you one question about the facts, which you just mentioned, being straightforward? I'm not sure they are, because it seems like there are some differences in the way you and Mr. Hobel see them. So the one thing I want to know about is, what is the evidence that Detective Harrison actually saw the arrest of your client?
Well, I think the testimony in both differs somewhat in the hearing, suppression hearing, and at the trial. But I think in both instances, after one reviews his testimony, it's clear that what he's stating is that he remained there briefly in the area as the suspect was leaving, and but he was in a hurry to get out to protect him from being identified, his cover from being blown, and that he saw the police coming in to make the arrest arriving as he was departing. And he sort of equivocates about that a little bit in the motions hearing, but I think it becomes clearer in the trial.
What is your view of the extent to which we can rely on trial testimony to bolster your argument to undermine the ruling of the trial judge? Aren't there some restrictions on using that kind of evidence?
Well, I think it certainly goes to the sufficiency issue that's raised, and that comes at the time of trial. Whether the court can review that and view that evidence after it's already made a ruling on the suppression without the defense counsel requesting the court to do so may be a different matter.
Okay, so you think that trial testimony it can be considered for sufficiency, obviously, but not in your suppression issue?
Well, I think that the court should have taken that into consideration at the time of trial and reviewed the suppression issue as a matter of perhaps plain error. But would have, and I think it does rise to plain error in the sense of defense counsel not raising it, but it being plain and an error not an error to make those findings of fact. While this court defers the trial court's findings of fact, I think the findings of fact of the trial court leave out, first of all, they don't, in the motions hearing, they don't address the factors that this court regularly requires the trial court to do. They didn't address reliability, and on this issue of suggestivity, it really didn't address any of the other factors that were raised during the hearing. And
Well,
such,
I can't find it right now for some reason, but I really thought there was somewhere that the detective, who was the only witness, right, at the suppression hearing,
correct.
actually said,
I saw them
I-
stop the defendant.
yeah, do you
It's
see
at
where
page
that is?
51 through 52.
Thank you. And then, yeah, so how do you get around that? It is, I
Well,
understand
if
that he says
he's-
some things that are inconsistent with that, but then whose favor do we resolve that in?
Well, I think that's resolved. The inconsistent thing, comes shortly thereafter. He's talking about both defendants. He's talking, and he sort of switches back and forth in his description of them. So it's not clear he's talking about Mr. Bennett versus Mr. Nelson. That's one factor. And how you resolve that is that the trial court didn't make adequate findings of fact based on the record.
Counsel, are you making that argument? Where do you make, so I see at page 51 and 52, the question is, you saw them stop both of these individuals at counsel table, both of the defendants, and he said, yes, I saw them stop the defendant. That's right there, which I read as being a reference to Nelson, but that seems like enough to say he saw them stop Nelson. And I don't see you making an argument in your brief that the trial court didn't adequately address that during its suppression motion, that it didn't adequately resolve the factual disputes. Where are you making that argument?
I think that argument, I believe, is addressed in the reply and addressing that particular issue. And I think it points out where I think it's on page 53 and 54 that the contrary statement is made. I'm trying to find that particular.
I'll search, counsel. I don't mean to hold you up on that.
Okay. So
Can I ask you one other, I just want to make sure I understand the record. So we also have Officer Turner. I understand that he doesn't testify, or I don't know about Officer Turner, but to what extent can we consider the audio tape that was played at the suppression hearing, which seems to involve a more specific lookout, not just the hoodie and the jacket and the pants, but also the tan boots. Is that in play?
well, I don't see it mentioned in the trial transcripts, but you may well be correct that I'm sure you're correct if that's what you heard in the.
Yeah, it's not
radio
mentioned in the suppression hearing transcript. It is mentioned a couple times at trial. But I don't know. Can you tell us what about
certainly-
this show up? I'm sorry. What about this show up is so suggestive?
Well, what's suggestive about the show up is that primarily the undercover officer says that he's making his identification solely on the clothing and the stature. He never describes what the stature is. It's never in either the radio run, as far as I know, or anything else. And he never just gives anything really distinctive about the clothing. And he never looks at his face under the circumstances. That's highly
don't
unusual.
Counsel, those don't sound like anything that goes to suggestivity. It sounds like you're making an argument about this is not such a reliable show-up identification, which you might be right. But just to repeat Judge Beckwith's question, in what way is it suggestive? Like more than any ordinary show-up ID?
Well, I think this, looking at sort of all of the factors in that, he's had a short opportunity to see the face of the suspect. Then he testifies that the observation is relatively fast paced.
Sorry, are you talking about the Biggers factors right now?
Yes.
And so I thought that once we have suggestivity in the pre-trial identification process, you look to the Biggers factors to see whether or not there is nonetheless a reliable in-court trial, whether or not there can later be a reliable identification. But those factors don't tell us whether or not the show-up itself is suggestive, do they?
Well, I think the I have to focus more on your question. I think the suggestive aspect of it, again, is it's presumed to some degree that a show up is suggestive. This is a police officer who's setting up a situation is suggestive in that he's only made a lookout based on the clothing factors, and there's multiple people in that area that fit that description: black male, black jacket, gray hoodie. He knows that as he's going through that area, and it's highly suggestive for the police to just take this one person fitting that clothing description only, which is common in that area. And the evidence both at the motions hearing and at the trial show that, makes that a suggestive determination. It's also highly suggestive that at the in-court identification phase that he uses the photograph of the arrest to apparently make a facial identification at trial, which he never made previously.
Now, that argument wasn't raised below, was it?
The argument wasn't raised.
That the photo was unduly suggestive. That tainted the in-court ID.
No, it wasn't.
Mr. Seligman, you asked to reserve a few minutes for rebuttal, and we'll give you that chance. Let us hear from the government, and then we'll call you back to the podium.
Very well.
May it please the court, Mark Hobel for the United States. The trial court did not err in denying the motion to suppress identification. Based on the evidence at the motions hearing, the trial court found that the undercover did not leave the area until he was sure that the arrest team had stopped the right person. The undercover testified at the motions hearing that he actually saw the stop of appellant.
Do you get the impression, reading the full testimony that's what he meant?
I think that at pages 52 through 53, he says, I saw them stop appellant, and I saw them stop the co-defendant. He then takes back the co-defendant, and then about a page later, he's actually asked by appellant's trial counsel, you say you saw them stop appellant. Do you recall who stopped him? And he says, I don't recall. So a page later, he's still consistent with seeing that. So the trial court's factual findings here were that he didn't leave the area until he was sure that the arrest team was stopping the right people, and that's not clearly erroneous, Your Honor. The trial court also credited the undercover's testimony that he had a sustained interaction with appellant, including an actual conversation and sharing of food. Credited the undercover that the stop, the show up ID was almost virtually contemporaneous with the crime, happened way under 10 to 15 minutes. It sounded within seconds. It sounded like on the radio run. So these factual findings, which again were not clearly erroneous, amply support the trial court's conclusions that the show up was not impermissibly suggestive.
Did the trial court actually find that Officer Harrison basically followed the man with his eyes and saw him get arrested?
The trial court's findings were that the undercover didn't leave the area until he was sure that the arrest team was going to the right person. So the trial court found that the period between the crime and the show up was essentially contemporaneous, and that as the undercover was starting to move out, the arrest team was moving in and focusing on the correct people, and that left very little opportunity or doubt about a misidentification.
The way that that Officer Harrison testifies, though, you do kind of get the idea that he's talking about the show up as something that could go either way, which is inconsistent with how could it go either way if he actually watched the man walk into the arms of the awaiting police officers.
So Officer Harrison's testimony about show-ups, it's an important part of the process. He wants to get it right. He has no bias towards picking the person that they picked. If it's the wrong person, so be it. But I don't think that's inconsistent with his testimony that he saw the stop. He also testified that while he didn't see the stop of the co-defendant, he saw one of the arrest team's cars pull up right next to the co-defendant's car. So I think.
I'm sorry, but is there testimony from other officers? This wouldn't come from Mr. Harrison, that they only stopped those two people. I mean, so there is. So here's how I understand the testimony. Harrison says he sees the approach. He leaves right about when they're stopping some people, including the guy he saw, and then he goes, and then he comes back later and does the show up. Do other officers say, yes, the first two people we pounced on, those were the two we arrested and showed to Mr. Harrison? Or is he just insinuating they saw them stop the guy that he later identified in the show up?
So the Officer Harrison was the only witness at the motions hearing. So there was not any testimony from other officers at the motions hearing. There was the radio run in which there's no indication on the radio run that there were other suspects stopped besides appellant and his co-defendant. I think at trial there was testimony from arresting officers at trial and body-worn camera footage from the arresting officer at trial who stopped appellant, and certainly at trial you can see from his body-worn camera footage and his testimony that he only stopped appellant. There weren't other suspects stopped besides appellant and his co-defendant. But I think that's, and going to a point that I believe Your Honor asked appellant's counsel during his argument, the trial testimony is not, because appellant did not renew his motion to suppress during trial based on any of the evidence that came in at trial, that evidence is really not properly considered to undermine the trial court's factual findings at the conclusion of the motion to suppress and denying the motion to suppress. But the evidence at trial was largely consistent with and corroborated Officer Harrison's testimony about just how immediately, the immediacy of this show up identification. Going to the question about suggestivity here and whether there was impermissible suggestivity. The critical factor that this court has found important with respect to show up identifications is the immediacy, the proximity of time and place to the actual crime. Here, the trial court's finding is it's virtually contemporaneous. The appellant finishes the transaction, starts walking back up the alley. Investigator Harrison is already calling the arrest team. The arrest team is literally passing Investigator Harrison in the alley. Another arrest team car comes in on Parkland, and they stop these suspects before there's any opportunity for these suspects to blend into the crowd. So with respect to suggestivity, there was no impermissible suggestivity here. The trial court's
Can you tell me, was that video of the body worn camera, did that come in at the suppression hearing?
It did not, no.
Okay, and what's going on there? It does look like one of the officers keeps saying, "Don't worry, we're not interested in you." And I wasn't sure who he was saying that to, but it does seem like there's more than just one guy there.
Right. So the officer, I believe it's McElhenney, he's part of the arrest team. The first person he stops is appellant, who he sees walking out of the alley. You can actually see in that video the arrest team, as Officer Harrison testified at the suppression hearing, the unmarked arrest team car coming up the alley. It's a white car. Officer McElhenney is stopping appellant immediately because he matches the description that was given in the radio run that I believe you alluded to earlier, the more detailed description: the gray hoodie, black jacket, black pants, tan boots, and black hat, which he has in his hand at that point. He's not wearing on his head. But there are other people around, but based on the description, based on the proximity, and the fact that he is walking out of this very alley, that body-worn camera corroborates corroborates the testimony that the investigator has given at the motions hearing.
But do you understand what's going on? Who the other guy is, or I just find it confusing. I don't actually know what's happening, but I wonder if your view. There seems to be some other person there who they're saying, "Thanks for cooperating. We're not saying you're involved."
I'm not sure. I think that may have been the officer saying that to appellant. I believe that's what Your Honor is referring to, because at this point he just knows he matches the description. He's coming from this alley.
And one other question, sorry, was the audio played at the suppression hearing?
The radio run, Your Honor.
Yes, radio run. Yeah.
It was admitted into evidence at the suppression hearing. I'm not sure it was all played, but it was admitted into evidence.
And what is the government's view about the relevance, or if any, of the more specific description?
I think it is relevant, Your Honor.
I mean, you don't mention it in your brief, I think.
We did not mention it. We did not mention it in our brief, but it is relevant, and it does go to the accuracy of the description. Now, that is not Investigator Harrison giving that description. That's one of the eyes, Officer Chaplin. But I given that it's over the radio, which all of this team is using, and it's not, it's essentially adopted by Investigator Harrison. So we do have this more detailed identification. But even with the somewhat narrower identification that we have involving the black male with the black jacket and a gray hoodie, that's still fairly descriptive given how quickly and immediately the stop is made. There was some testimony there actually was no testimony during the motions hearing about other people in black jackets. That comes at trial. At the motions hearing, there's simply testimony that it can be fairly crowded on Parkland, the street perpendicular to the alley. But at trial, the testimony is there are other people with black jackets on, but there isn't any testimony about black jackets and gray hoodies.
Counsel, can I move you past the show up ID for a moment? Because we haven't had a chance to talk about the in-court ID. Let's take the show up ID out of the equation and say, Officer Harrison had this interaction with Mr. Nelson 10 months earlier. I don't know how long it was. I don't think there's a finding on it. Call it 30 seconds to a minute. And then he gets up at the suppression hearing, and then again at trial, and they hand him a photo. And the defendant's sitting there, and they say, "Is this the guy?" I take it you'd agree with me that is a more suggestive procedure than just your typical in-court ID. That there's something suggestive about handing him the photo of the defendant who's sitting in front of him in cuffs at the scene, right?
I think that can depend on a lot of factors that unfortunately are not in the record and in the transcript here, because appellant did not object or raise this issue.
I take your plain error point, but what factors don't we know? I mean, we know enough about his opportunity to observe on the scene. We know enough about his certainty that he expresses. I mean, what factual matter would have been developed had the appellant raised this in the trial court?
Well, given that, I think the argument that he is looking at the photo, then looking across the room and saying, "Oh yeah, oh that's the guy." I think there is a strong. The inference is that he's making the inference that's being argued by appellant is he's making the identification based on the photo. Identification issues are very fact specific. That's why there's considerable deference to the trial court here, and findings related to whether to the bearing of the witness, to the ability to perceive the defendant in court. I think certainly it would have benefited from development, but unfortunately there was no objection, and the trial court certainly didn't sua sponte see an issue here, spot an issue here. Defense counsel didn't raise an issue, so I think
the issue here is not quite the one that's been posited, because the issue here arises after there in fact was an on-scene identification. So the officer is not being shown the photo 10 months after the arrest and being asked to make an identification of any kind for the first time at that point. So that issue could not have been raised in this case. Isn't that correct?
I think that is correct, Your Honor, and I think that sort of connect. I think that relates to the United States
And
v.
it's
Branning.
contrary, of course, to the defendant's theory at trial, which was that there was a suggestive out-of-court identification that influenced the in-court identification, not the reverse. That forget about that out-of-court identification. What was problematic was the suggestivity of the in-court identification. That argument was never raised.
That's correct, Your Honor. It's raised entirely for the first time on appeal. The focus of appellant at trial was entirely on the out-of-court identification. And I know too that the United States v. Branning case that we've cited in our brief, that involved a constitutionally acceptable out-of-court identification, which we have here, a non-suggestive show-up identification. This court held as a matter of law that showing a witness a refresher photo prior to a pretrial hearing, even though unlike here, and frankly more suggestively than here, it was shown out of court to the witness, that did not offend due process.
What seems peculiar here is that the out-of-court identification in this case was of the person's back.
Right.
If we put aside the testimony, I saw them arrest the person. Nobody explored that testimony. So one can ask, I mean, two questions one could ask is, well, how suggestive is it that to have been shown somebody's back? It's hard to see how there's any suggestivity there. But also there is the question of how reliable it is to have been shown somebody's back. Is this very common for police undercover officers to make identifications on the street in this fashion?
The most we can say from this record is that there was testimony from one of the other officers that this was not typical or usual. But there was also testimony from Investigator Harrison that this was not typical or usual because of the speed with which the arrest team came in to stop the defendants, that he did not have time to leave before the arrest team was already coming in to stop the defendants, and that he saw that. So I don't think that it's, I think based on this record, it sounds like it's not typical, but I think, again, the immediacy of this confrontation was also not typical.
I mean, they could have, if they had wanted to, taken a few minutes more time and arranged a more suitable show up, but that's neither here nor there. The issue is really one of suggestivity. Well, I think we've heard from you, and I think we'll now, from the government, that I think we'll now give Mr. Seligman a couple of minutes for rebuttal.
Thank you, Your Honor.
Thank you. Mr. Seligman?
Thank you. I want to emphasize the reliability factors, the biggest factors, and something also in the trial judge's observation. He made a lot of they had a meal together, suggesting that there was this relaxed time to observe and see the suspect. But in reality, what was happening was, from the basis of the officer's testimony, both at the suppression hearing and at trial, is he was somewhat surprised by the suspect's approach because he was in the middle of taking a break. And so he had to scramble, and things went very fast in that sense.
Mr. Seligman, can I interrupt you? Just that I think the last thing Judge Glickman said is this all really seems to come down to suggestivity. I think your time might be best spent talking to us about why you get over the first hurdle.
Well, I've done my best to answer that previously, I have to say. Whatever other answers to that would be in my brief. But I do want to say that I think there is an issue of the reliability of the evidence in the context of whether there was sufficiency. And there was sufficient evidence given the total picture here in terms of the unreliability of the identification, which is the linchpin of identification, regardless of whether there's a finding of suggestivity or not. And that goes to the ultimate issue of whether there was sufficient evidence, and that's been argued. And the same factors which I was about to outline are there. And that is that he didn't really have a lengthy period of time to observe him. He never made a facial identification. He had generic clothing by the officer's own description that and the officer's own admission at both hearings, at both the hearing and trial, there were others matching that description.
But the truth is that these, I'm sorry, Mr. Seligman, the truth is this evidence came in, and you're kind of balancing and talking about reliability. I mean, those are arguments for a fact finder and for a jury, but it doesn't sound like the stuff of insufficiency. Like, could no reasonable juror, given that these IDs came in, or no reasonable fact finder have found guilty?
Well, our position is no reasonable fact finder could rely on the identifications in this case, that they were unreliable, both as to the out of court and in court identifications for the reasons stated. And that this making the ID from the back was highly unusual, and was, if I believe, suggestive under the circumstances that this was the same person that he made the deal with without making the effort to look at his face and verify that. There's nothing about this that made it unusual in terms of his security that justified his not making a facial identification. And that was, the jury was ultimately confused by the in-court identification, which is very powerful. And the court cases show that in-court identifications are quite powerful, and that was not really dealt with, as you've noted, by trial counsel, but the court should have stepped in under these circumstances with such an unreliable identification. So I ask that the case be reversed both on the suggestivity and unreliability, and alternatively that the case be and remanded, and alternatively that it be reversed on insufficiency of evidence. Thank you.
Thank you, counsel. The case is submitted. We will call the second case on the calendar, Classic Cab versus District of Columbia Department of For-Hire Vehicles. Counsel, Mr. Riley for Classic
Good morning.
Cab.
Good morning, Your Honor. Sean Riley on behalf of Classic Cab.
You may proceed.
Thank you. And thank you for the opportunity. Your Honor, I'd like to ask the court to allow me to reserve 3 to 5 minutes for rebuttal.
That'll be fine.
Thank you. Your Honors, this is a case involving the denial of Classic Cab's light 2018 license application for renewal of its operating authority. DFHV, based completely on hearsay as the sole basis for to revoke the license, revoked the license and did so for arbitrary reasons.
Was it a revocation of a license, or was it a decision not to issue a new license?
It was a denial of a renewal of a license. So
now the government argues that this appeal is moot.
Yes.
Would you like to speak to that first? Because if it is moot, then we don't reach any other issues.
Yes, thank you. Your Honor, what I would say to that is that mootness of an appeal depends on the nature and circumstances that cause the mootness, if there is mootness. And the DC Court of Appeals in the Thorne case laid out 2 factors to look at when analyzing whether mootness is present. And one factor was whether the conduct by the appellant was involuntary or voluntary. And the principal factor is whether or not the party seeking relief caused the case to become moot. And here, the event or thing that caused the mootness is DFHV, is the revocation or denial of operating authority, which caused Classic Cab to shut down. And what that means is that their decision to renew their operating authority, you can't operate a taxi cab company in Washington, D.C. without operating authority. So when you lose your operating authority, it means you lay off your workers. It means that you can no longer rent cabs to the cab drivers that were renting cabs from you. You can no longer pay your rent. You can no longer pay your utilities. You can no longer maintain the lease or pay insurance on the vehicles or maintain the car lease for purchasing vehicles. So if there is any mootness, it's caused by DFHV. They have caused the mootness. The second
Well, I'm
factor-
not sure I understand that. The mootness is caused by the fact that, according to the affidavit that was submitted, that Classic Cab now owns only 7 vehicles. If we were to say the administrative agency here got it wrong, Classic Cab would still own only 7 vehicles. If Classic Cab is able to get more vehicles, the necessary number to, under whatever theory is Classic Cab's theory of operation, they would then have to then be able to apply again. And they would say, okay, we now meet the requirements. And we have arrangements in place. We can't operate yet until we get the certificate of operation, but we can apply now. Nothing stops you from doing that if you're able to do it. And by the same token, if you're not able to do that, I don't understand what relief we can provide.
Well, what Classic Cab is asking for is appropriate relief, which would be operating authority that was unlawfully denied by DFHV, and a reasonable time to come into compliance and attain enough vehicles to meet the requirement. And what I would focus the court on.
Why haven't you had a reasonable time to do that now?
What we've
I
been
mean, your
denied-
theory is that if you've got a fleet of 20 cabs, whether you own them or simply control them, then you're entitled to an operating certificate. The government's theory is you have to own all 20. Okay, there's a dispute there. But even by your own theory, you don't have the control over the necessary number of cabs. Now, nothing stops you from, and you wouldn't have it if we reversed the decision under review. By the same token, nothing stops Classic Cab and its owners from going out, making arrangements with people to have what it considers to be the necessary number of cabs and coming back and reapplying and saying, look, we realize we can't put them on the street tomorrow because we don't have an operating license. But once you give us the operating license, we'll be able to do it. But that doesn't seem to be Classic Cab's situation. So I'm having trouble understanding why this case hasn't become moot.
It has not become moot because without the operating authority, you're not going to be able to get taxi cab drivers to join.
Well, how does any taxi cab company start up? It starts up by getting the arrangements in place, and then it applies for the operating certificate. Until it gets the operating certificate, it's not going to be able. It might not be able to. No, because it might be able to invest in 20 cabs, but it doesn't happen. It still couldn't operate. It would be in the same position as Classic Cab, wouldn't it?
Well, I mean, you can't, Your Honor, you can't do anything with a taxi cab company if you have no operating authority. So it's sort of like a cart before the horse, in that Classic Cab would ask for the relief to have operating authority, and then have a sufficient amount of time to come in compliance. And I'll make an analogy to.
But let me put it this way: your license, your operating authority expired on October 2018. The question is whether you can get a new operating license, right?
And we
To
could.
get a new operating license, you have to show that you can meet the requirements for a taxi cab company.
What-
Now, I understand your point that if you're not going to be able to get the license, you won't be able to meet those requirements because nobody will want to join up with you. But that doesn't mean you can't get together the necessary number of cabs and owners of cabs and so forth and said, okay, we're ready to go for hire vehicle commission. We will meet all your requirements. Give us the license. Nothing stops you from doing that, I don't think.
Well, I don't think that anything would stop Classic Cab from doing that. But for DFHV's actions here, they're in a place where they shouldn't be, meaning that they shouldn't have been unlawfully shut down for arbitrary reasons. And what I would say, Judge, is that if they had operating authority, the operating authority would put them where they would have been. And the application, the time for the application is December 15th, 2021. So that's when the application is due. That is the only relevant time by the regulations. The regulation I'm referring to is DCMR 3301. I'm sorry.
What?
Let me start again.
December 15th, 2021 is what? What date is that?
December 15th, 2021.
So what is the import of that date?
That is the date of the renewal application, right? So that's the next period of renewal. It's an annual renewal, and it's annual by regulation. And the date every year set by regulation is December 15th of the year. All right. So if they had the operating authority and an opportunity to and sufficient time to get enough vehicles, which they can do, the next time they would have to prove that they had the vehicles would not be until December 15th, 2021. But it wouldn't be for this period. I mean, this case is going on now. It's December 1st, right?
But you have not made a showing in response to the claim that this is moot. You've not made a showing that, or even represented, that if we reversed the taxi cab decision, you'd be able before December 15th or at any time to get the necessary number of cabs to maintain a fleet.
I mean, I would assert that they could do that, and it's reasonable.
Well,
to,
I mean, what do you mean you could? I'm sorry, go ahead.
They have every intention of. They've been in business since 2006. This is what they do. They have every intention of restarting their taxi cab business. What I would say to that is that the second part of the Thorn case was that mootness can be defeated by actions taken to preserve the status of the appellant during the appeal. If I can just find that site. The Thorn case says, nevertheless, a party may escape the doctrine of mootness by taking appropriate action, such as seeking a stay of a court order. Classic Cab has they have filed at least 9 stays to avoid the problem that we're discussing.
Well, the stay was denied. Maybe this is a good segue into the question of the merits. As you know, the stays were denied. Basically, how do you respond to the argument that the definition of a taxi cab company requires that the company own as well as control or operate at least 20 taxi cabs, and that Classic Cab did not meet that definitional requirement?
What I would say is that what the definition says is that unified control of the company can be by ownership or by the company. And so if they're...
Well, I don't know if I agree with you about that.
No,
there is a problem. Read the first sentence of DC Code section 50-301.03, the definition of a taxi cab company.
Yes, would you like me to read that?
Well, it's any corporation engaging in the business of, quote, owning and operating a fleet or fleets of taxi cabs having a uniform logo or insignia. So it envisions a corporation that is going to both own and operate a fleet. And the fleet is a defined term too.
Yes.
And a fleet is defined to mean 20 or more cabs. That's the essence of the government's argument. How do you respond to that?
What I would say is that if unified control of a fleet can be by ownership or by the company, then that means that it couldn't just be 20 by one person.
You're saying that the second sentence of the definition is apparently inconsistent with the first sentence.
I would say that the second sentence puts the entire definition in the proper context of what it's trying to communicate.
You mean the
So
second
this-
sentence of the taxi cab company definition?
Yes, Your Honor.
And are you relying at all on the definition of fleet?
Yes. And
And
yes,
does that play into that? I just want to make sure I understand that argument. Is it that the fact that by association is included in there changes the definition of taxi cab company because that includes fleet? Am I getting that right?
if I,
Not quite. You tell me.
it's kind of a convoluted definition, but what I would say is that taxi cab company is different from a taxi cab association, and that a taxi cab company only includes a fleet. And for more clarity on that, you could also look at the DCMR definition of taxi cab association. We're looking at the code, but if you look at the taxi cab association and taxi cab company definition in DCMR, also with the definition of taxi cab association, it does not include fleet. And I think that if you don't have a distinction between taxi cab company and taxi cab association, then they are identical. And the difference between the two is that taxi cab company includes a taxi cab fleet. The taxi cab fleet is classic cab. Did that answer the question?
I think so. You mean it allows you to combine the cars or the cabs?
I'm sorry, go ahead. Answer that question if you would, please. And then you ask for 3 to 5 minutes in rebuttal, which we'll give you, and we'll hear from the government.
Very well. I would say that classic cab met the definition of taxi cab company because it had a minimum of 20 cabs that all had a uniform logo and insignia, and it was under the unified control of the company.
Okay.
the
Not
taxi-
all owned, but that number, but not all owned.
Not the unified control by the company. And so what unified control by the company would mean is that the company is referring to the leadership of the company, as any other company, with a president or a CEO or a lead manager of some kind. And in that arrangement, taxi cab drivers pay fees to the company for what Classic Cab does. Classic Cab is responsible and accountable for all business licenses. They're accountable for paying the rent, for paying utilities, for the equipment, for hiring employees, for perhaps the business tax, for the dispatch service that they provide. And in exchange for that, they're also held accountable and they're responsible for all liability. In exchange for that, taxi cab drivers pay them a fee, as all taxi cab companies in the city, how a taxi cab company would work.
Okay.
They would
Let us
also
give you
carry
5
the
minutes.
insurance and the bond for the company.
Mr. Rowley, thank you. We'll give you 5 minutes in rebuttal. Let us hear from counsel for the commission.
Good morning, and may it please the court. Jacqueline Bashar for the respondent. I'd like
I'm
to
sorry,
begin
your
by
name is not
returning
on our-
directly to the court's discussion with my friend on the other side regarding whether there remains a lot.
Excuse me.
I'm sorry?
Yes, excuse me. I want to interrupt you for a second. Your name is not on on the sheet showing, we have Stacy Anderson's name here as the counsel. Let me just write down your name, please. What is it, Jacqueline? How do you spell your last name?
Bashara.
Bashara?
It's B as in boy,
Yes,
Echara.
thank you very much. Okay, why don't you begin again if you don't mind? Go ahead. Can you hear me?
I apologize. Are there connection issues on the court's end or on my
We
end?
think it, we
Okay,
think
I
it's on your
apologize.
end, but we're not sure.
Okay, is that better?
Seems like it.
So far, so good.
All right, I apologize for the technical difficulties. So returning to the mootness issue, Classic Cab has admitted here that it no longer owns enough cabs to operate as a taxi cab company, even under its interpretation of the statute. The relief that it's requesting from this court is to reverse and to immediately reinstate its operating authority. However, this court simply cannot provide that relief since Classic Cab that is not able to operate as a company with fewer than 20 cabs, however those cabs may be affiliated.
Mr. Riley seemed to be arguing that whether we should treat this as moot turns on whether its conduct was in some sense involuntary or voluntary, and whether whether Classic Cab was bears the responsibility for causing the case to become moot. How do you respond to that?
So to begin, Classic Cab had the opportunity to raise this argument in a reply brief, and it did not do so. So it is problematic that this is the district's first opportunity to learn of this argument. The case Thorne was never cited in Classic Cab's briefing at any point in these proceedings.
It was cited in the district's briefing, however.
Correct. But to address the question of who is to be held responsible, it's important to keep in mind several factual points. First off, Classic Cab had notice of this defect because a representative of the department, Mr. Lindsay, met with Classic Cab's owner on a monthly basis during the operating period to go over their vehicle inventory. And when he realized that Classic Cab would fall below the 20 vehicle minimum at the end of 2017, he flagged that issue for Classic Cab's owner. And he specifically asked him how he planned to come into compliance before he applied for renewal of operating authority. And he warned Mr. Jelani that if Classic Cab fell below the 20 cab minimum, its operating authority likely would not be renewed. Further,
Sorry, that communication was with regard to how many cabs were owned by Classic Cab or otherwise associated with Classic Cab?
That information concerned how many vehicles Classic Cab owned. So by the end of 2017, several cabs that were credited as being owned by Classic Cab would age off of the road because they would be too old to operate. And so then Classic Cab would only have 14 cabs that it owned.
I don't see how that's responsive to the mootness point, which is even if he's right that the other cabs that were associated got him over the hump of 20 cabs, and he's right about that interpretation of the regulation that really they shouldn't have to own all of them. I don't understand how you're responding to the mootness point that, he had enough cabs lined up to operate under his interpretation up until the revocation occurred or denial of renewal of the license. And so that it was really an involuntary fall below 20 in the in terms of associated cabs.
Well, so there was an avenue for Classic Cab to keep this case alive while it litigated the definition of a company. Specifically, when its renewal application was denied, Mr. Lindsay advised Classic Cab's owner that they could apply to operate as an association. They could have done that and continued to litigate. They also could have affiliated their remaining cabs with an existing company or association, and that way maintained the vehicles that were still in their fleet.
Let me ask you a question. This, in a way, makes the mootness issue turn on. If you go down this route, which I'm not sure is the right route to go down, it makes it turn on the correctness of the alternative definitions of taxi cab company that are being argued before us. Do you think that the second sentence of the definition of a taxi cab company in the regs or in the statute is in tension with or inconsistent with the definition you offer, the interpretation you offer of the first sentence?
Certainly, the statute is not a model of clarity. However, the department's interpretation reasonably construes the second sentence in conjunction with the first sentence to require ownership by a person, partnership, or corporation. Classic Cab's interpretation would simply collapse multiple defined terms by reading company and association as equivalent.
Well, I wonder, let's see. I mean, let me give you a hypothetical. I'm trying to decide in my own mind whether we should jump to this hypothetical yet or press you a little bit on your statutory interpretation. But let's jump to the hypothetical. Suppose Judge Beckwith and Judge Deal and I each have 10 cabs, and we decide we want to be a taxi cab company. Okay? Each of us owns 10 cabs. We sort of amalgamate and form a company called Judge's Taxi Cab, probably in order to violate as many ethical requirements as we can. Judge's Taxi Cab leases the 30 cabs from us, does not own them. And then Judge's Taxi Cab Company operates the 30 cabs. In your view, and controls them, and we just sit back and receive our dividends and profits. But we retain title, legal title. Each individual judge retains title to the 10 cabs that they contributed to the operation. In your view, is that a taxi cab company or is that a taxi cab association?
So my understanding is that this leasing problem is unlikely to arise because in the normal course of the taxi cab business, in order to operate the vehicles as taxis, the business needs to paint them with specific colors and put its logo and insignia. So in a traditional example where, for example, a dealership wants to lease, let's say 20 cars to a business, it would be unlikely to allow the business to do that pursuant to a lease term. But in any event, according to the department, if one person or partnership or corporation, their name was on the lease for 20 cabs, that would be sufficient to establish unified control either by ownership or by the company.
Well, now you've segued into the word "or," when it has seemed to me that your whole legal theory rests on the word "and." The first sentence of the definition of taxi cab seems, and this is how I believe the government, hello, have you gone? Have you disappeared? Have we lost? Oh, I'm sorry. My apologies. The first sentence of the definition of taxi cab company, on which I understood the government to be relying, is a corporation that owns and operates a fleet. An operation by itself is not enough without ownership. That I thought is the government's position. But now you're saying ownership may not be necessary if they have some other form of control. And leasing is the form that I hypothesized. You want to explain that a little bit?
Yes. So
Because if that's true, then maybe Classic Cab is correct in saying, look, we didn't own, but we controlled over 20 cabs because the owners of several of them essentially gave us the requisite ability to control them.
Right. So the agency did not pass upon this leasing question because Classic Cab did not put it to the agency. Classic Cab did not introduce any evidence that it had unified control. To be sure, it makes those allegations in its brief and in its argument today, but there was no such evidence before the hearing examiner or the director to rule upon that method of satisfying the statutory requirement. The statute is, there are some internal redundancies perhaps, but that makes it an especially good case for this court's deference to the director's interpretation.
Well, I understand the argument that where there's ambiguity, we defer to a reasonable interpretation of the agency that administers the statute. But I'm not quite sure that gets you where you want to go here. Could you do you have the statute in front of you that we can actually parse the word? Okay.
Yes, I
Tell
do.
me if you would, your explanation of how. So you use the word redundancy. I would like you to explain to me how the first sentence and the second sentence are not redundant, but are actually consistent with each other. Tell me how they're consistent. The first sentence seems to say, unless I'm misreading it, that a taxi cab company is a corporation engaging in the business of owning and operating a fleet or fleet. And fleet is a defined term, meaning, among other things, 20 cabs. So the first sentence seems to say that the taxi cab company, to be a taxi cab company, the entity has to own and operate a fleet. But then the second sentence, let me see if I can find it verbatim.
Company must have a minimum of 20 taxi cabs, having unified control by ownership or by the company.
Yeah, by ownership or control, having control by ownership or control. How is that second sentence consistent with the and control, ownership and operation of the first sentence?
So it may be helpful and perhaps a little more concrete to look at the examples providing in the hearing examiner's decision interpreting these provisions together. So under that interpretation, which
decision is that, did you say?
I'm sorry, the hearing examiner's,
Oh, the hearing
the
examiner.
October 12th, 2018 final order. So in that decision, the way that the agency is construing, and of course the director adopted this interpretation, the way the agency is construing these provisions is that, so unified control by the company means that the company itself is owning and operating a fleet or fleets of taxi cabs. Unified control
Unified control by the company means the company is owning
and operating a fleet.
And operating?
Yes, that's correct.
So why the disjunctive?
So to continue, unified control by ownership indicates that an entity other than the company itself can own the cabs and it will still qualify as a company. So specifically in the hearing examiner's opinion, he gave the example of a person who owns 20 cabs. There could also be, it's not referenced in that opinion, but of course the statute references a partnership. And so that would also fit within the by ownership part of this disjunctive.
All right, so to be sure I understand, give me an example, an actual concrete example of a structure that satisfies both the first sentence and the second sentence.
Okay.
In other words, give me an example of a structure that I keep losing my page containing the definition of the statute here. Forgive me. Hold on one sec.
And I assume
A company must have a minimum of 20, the second sentence is a company must have a minimum of 20 taxi cabs having a uniform logo or insignia, and having unified control by ownership or by the company. So let's say, so that envisions a division between the entity that owns the cabs and the entity that has unified control of them, correct?
Yes, so to respond to your question about a concrete example, and I see that my time is about to expire. May I continue?
You please do.
Okay, so let's say, for example, that two people, A and B, own a company. Together, they have formed this company. And person A owns 25 cabs. So in that instance, because person A owns the 25 cabs, so that's unified control by ownership, that entity that was formed by person A and person B could operate as a taxi cab company.
If the taxi cab company, what, operates the vehicles?
Well, yes, the vehicles would be operating under the authority of that company.
Even though it doesn't own the cabs.
Well, a person who has a stake in the company, who is an owner of that company, has the control of the cabs by ownership.
So now, why is it that Classic Cab did not satisfy that example you've just given?
Because by the end of 2017, Classic Cab had 14 cabs, which were credited as being under the company's unified control, but there were 14 cabs that were operated by individual owner operators. So each of those individuals owned separately those 14 cabs. And so those 14 cabs did not count toward the total number of cabs that Classic Cab owned.
Sorry, go ahead. On the hypothetical that you give, how does it satisfy the first sentence of being in the business of owning a fleet of cabs? If you're positing that the company itself doesn't own any cabs?
Classic Cab?
I'm sorry. So I think in answer to Judge Glickman's question, your answer was, let's say A and B form a company. A owns the cabs, but the company doesn't. How does it satisfy the first sentence of the regulation that the company is in the business of owning a fleet of cabs?
Well, it would be the person is engaging in the business of owning and operating a fleet or fleets of taxi cabs. Because the person owns
the problem is that the person is not, I mean, there's two problems that I see here. One is that whenever we talk about this, you and I, or Mr. Riley and I, or other people, the words ownership and operator and control get thrown around interchangeably and used loosely when they are different words and they have different meanings. And in the regulation, first regulation seems to say the company must be the owner, first sentence. It doesn't say the company or one of its principals or anything of the sort. And the way these definitions are written have meanings and they require certain things to be met. And then and the first sentence uses the term owning and operating. The second sentence then uses the term control and operate and by ownership or by the company, suggesting that somebody other than the owner can control the cabs without owning them. Well, that's interesting. How does that comport with the first sentence, which says the company has to own and operate? Does control mean something different than operate? Do you understand why this is a problematic definition? And why we're having trouble with it?
Yes.
Now, Mr. Riley's position, I think, is that they met the second sentence. They had more than 20 cabs, and there was unified control of those cabs by Classic Cab. And he admits that Classic Cab did not own all of them, But you seem to be saying that's okay, despite the first sentence. I thought the point of your brief was that the first sentence requires the company to own a fleet, meaning 20 or more cabs. Not somebody else own the fleet, or part of the fleet, but the company. But now I hear you say something different. Am I wrong about that?
Perhaps it would help to clarify. The first sentence says that company means any person, partnership, or corporation. So the first sentence is more broad than simply the company. Perhaps.
Well,
that
everybody
goes to the
understands
first-
there are different structures that can create a company. A company isn't necessarily a corporation. It can be a partnership or a limited liability company or any, or it could be an individual, for that matter. But it has to be a defined entity.
Yes,
That's
Your
what-
Honor. So the problem
I
with
mean,
classic
when we say
cabs,
when we say a partnership, for example, must own 20 cabs, that's different from saying, well, there are 20 individuals who are, happen to share, who each of whom owns one cab.
right, that would be a group of owners, which is the
An
first
association.
sentence of the definition of an association. Exactly.
So it makes a difference who the owner, the actual title holder is. I thought. Now I'm not so sure.
Your Honor, the problem with classic cabs proffered interpretation is that, first of all, as I mentioned, there is no evidence in the record for this court to reverse the director's determination based on classic cabs assertions now that it somehow had unified control based on a variety of factors that simply were not presented to the agency. Now, my understanding based on their brief is that classic cab maintains that they had unified control by association, but we know that can't be enough because that's not in the definition of a company, but it is in the definition of an association. And as you noted, we presume that when the legislature uses different words in different provisions of the same statute, it intends to convey different meanings. So unified control by ownership or by the company, at the very least, must mean something different than unified control by ownership or by association.
Ms. Butara could, I'm sorry, go ahead, Judge.
I'm sorry, Judge Beckwith. On page 13 of the hearing examiner's decision, it says expressly, petitioner argues that its company, by way of having at least 28 taxi cabs having uniform insignia, and et cetera, that it has unified control by association. So the court must consider whether the vehicle ownership requirement is satisfied where they have unified control by association. I mean, it seems like this argument is considered. It doesn't seem like this is a late-breaking argument that's first being made on appeal, which is how I think you're describing it. If it's so late-breaking, why is the hearing examiner addressing it so directly?
So I agree that classic cab did suggest that it had somehow unified control by the company. It's in its brief on appeal that classic cab first brings to light the claims that it pays for the rent and it hires the drivers and so on and so forth about fees and other responsibility that classic cab has undertaken that show that it somehow has unified control. Those factors were not put before the agency.
Did the commission ever dispute that classic cab had unified control over I don't know what the total number of cabs is, but it's more than 20 cabs that it was that it had under the same insignia and all the rest?
So
I didn't think that was the issue in dispute.
the department credited that classic cab did own 14 cabs. It's just that the remaining 14 cabs in its fleet, it could not satisfy this ownership requirement.
Right. The department took the position that classic cabs failed because it didn't have ownership in the name of classic cab, legal title to 20 cabs. But the problem I'm having, Ms. Butara, is that I'm hearing you say that, well, actually ownership of all 20 isn't required for a taxi cab company. And B, you're saying because because if the company has unified control over those cabs, that might be enough. And yet, I don't think that there was, what I'm asking you is, was it actually disputed that Classic Cab had unified control over all those cabs?
Over the cabs that it didn't own?
Yeah, I mean, it sounds
Right.
like that was not really challenged by the department, because the department took the position, it's irrelevant, you have to own all 20 or more.
That's correct. And if there was anything unclear in my responses, to be clear, the department maintains that there is an ownership requirement. I was simply addressing that Classic Cab maintains that it could satisfy unified control by the company through some other means, but that is not the agency's interpretation, nor has it made such a showing below or in this court.
Who has to own the 20 cabs to be a taxi cab company?
So
If
it could,
the taxi cab company's sole shareholder, not that this is this case necessarily, if the taxi cab company's sole shareholder owns the cabs and says, all right, and I'm incorporating a company to operate them and have unified control over them. They're in my name. They're not in the company's name. That's not company ownership of the cabs, okay? Leaving aside piercing the corporate veil, let's assume they obey the formalities. Now, is that a taxi cab company or not?
so it's a sole shareholder that owns the cabs?
We're going to move on from that sole shareholder in a moment, but I just want to deal with, I just want to have I'm telling you that I read the government's brief here to say that one thing that the sentence requires, the first sentence of the definition, is dispositive because it requires the taxi cab company as an entity to be the owner of at least 20 cabs. Okay, if that's what it says, it says. That Classic Cab does not meet that requirement. But now I hear you saying that, well, it doesn't really mean that.
Well, Your
And
Honor,
that, and I want to know what it does mean.
the company could mean more than just the company. I think that's what the first sentence is clarifying and what the disjunctive in the second sentence is also putting through. So if we think about the example in this case, Mr. Lindsay testified, and if we look at Exhibit 101, I think there was actually only one cab that was titled in Classic Cab's name, and then there were several cabs that came from Mylan Transportation and Jelani Group. And so those two entities merged with Classic Cab. And so once those entities had merged, the department accepted that all of those vehicles were now owned by Classic Cab because it was shared ownership. They all had a stake in those cabs.
When you say merge, are we talking about a formal merger of two corporate entities?
Yes.
Well, all right, so that produces a new corporate entity. Okay. But that's not what we're, I mean, Classic Cab is saying, look, we corporate entity Classic Cab have 14 cabs, but we are in an association, if you want to call it that. It's a word, could just mean a partnership, with some owners of some additional cabs. And they have ceded to us the ability to control. So we have unified control over those cabs. Now, hypothetically, let's accept that those facts are true, and that as a result, Classic Cab owns 14 cabs and has unified control over more than 20 cabs.
That would not satisfy the definition because it's saying it has unified control by association.
What does association mean as opposed to some other
It
terminology?
means a group of owners that have come together and formed some kind of entity.
How is that different from a partnership? Which you told me a few minutes ago can satisfy the definition of company.
The difference is, let's say there are 20 owners and each owns an individual, a single vehicle, whereas with a partnership, one person in the partnership owns the 20 cabs, or perhaps 20 cabs are in the name of the partnership, and that would satisfy the company definition.
You're segueing into the notion that there must be unified ownership of 20 cabs. And I thought earlier you were saying, well, no, you don't have to have unified ownership of 20 cabs. I mean, if the position is you have to have unified ownership of 20 cabs, that's what the first sentence means. I understand that. And then my question is simply, well, how do you square that with the second sentence? Maybe the answer is, look, this is a poorly worded statute. Things are, the sentences have a seeming inconsistency, but this is how the agency interprets the definition. But you haven't quite said those things. Instead, you've been saying, I think, that there are circumstances where the company does not need to have unified ownership, and it can still be a taxi cab company. That's the difficulty I'm having.
So, Your Honor, I'm not sure that there is inconsistency between the two sentences. It seems perhaps the problem is that there is some redundancy between unified control by ownership and unified control by the company.
Well, it posits a difference between the owner and the company.
That's one way to interpret it. To give meaning to the first sentence of the statute, it's reasonable to understand that ownership means a person or partnership, and by the company means by the company itself.
Well, we've taken you, I've taken you, you could say, far beyond your time. Let us hear from Mr. Riley in rebuttal.
Thank you. Very well. Thank you. What I would say in rebuttal to a few of those points was that, DFHV had the burden in this case. It's not sort of a throw up and just you come to court and prove you have 20 cabs. They have denied a license application, and it is their job. They have the burden of proof and burden of production to prove that there was a deficiency in that application in 2018. And
why do you say that? I would have thought that the applicant has the burden of showing that the applicant has met the requirements.
No, Your Honor, they have the burden of proof to prove the deficiency that they alleged. There's a regulation to that effect, but I can't put my hands on that right now, but they have the burden of proof and the burden of production. And I argued that at trial that they absolutely had that burden. It's not Classic Cab's job to come and present evidence that it's in compliance.
Once they show that the taxi cab company, once they show that Classic Cab does not own a fleet of taxi cabs, why haven't they met their initial burden?
They didn't meet their initial burden because of the way in which they tried to meet their burden was through all hearsay.
Oh, no, let's forget that. Let's assume that, forget about the problem of hearsay. Let's assume the evidence was competent and admissible.
Okay. It did not establish anything because their witness said that Classic Cab had unified control. All the vehicles had the same colors and insignia. And their witness, Mr. Lindsay, acknowledged that in the record. And so based on our definition of taxi cab company, taxi cab association, and taxi cab fleet, that was our argument. DFHV representative it's not correct. That was our argument.
Are
I'm
you
sorry.
saying, I understand that the taxi cabs all have the same insignia and logo. Are you saying that Mr. Lindsay acknowledged that there was, quote, uniform control over all the cabs?
I believe that he did acknowledge that Classic Cab had unified control over the Classic Cab.
In so many words?
You know, I don't have the transcript, Your Honor, but I believe that that is what came out on cross.
Because Ms. Bashara is saying that there was no proof that, if I understood correctly, that no evidence in the record of unified control by Classic Cab of the requisite number of taxis. Now, this is something that you ought to be able, if there was evidence, to say, here it is on page such and such, the testimony was X.
That argument was not raised by DFHV at trial. The evidence that I'm referring to is based on my cross-examination of Mr. Lindsay, and Mr. Lindsay acknowledging that, for one thing, Classic Cab was in compliance with DCMR 501 with met all the requirements for getting approval for an application, and that Classic Cab maintained a fleet of taxi cabs, all with the same colors, the same insignia, and they all were at the same business and so forth address of Classic Cab, that they were under the unified control of Classic Cab. And based on my recollection of my cross-examination, Classic Cab didn't put on a case, Your Honor. Classic Cab didn't, because we didn't believe that DFHV had met any burden because the evidence was insufficient. But what they believe they established, we don't think established a violation of the taxi cab company because of our interpretation of taxi cab company. So we don't believe that they proved that there was a deficiency in the 2018 application for
I take
renewal.
it you agree that as of now, Classic Cab cannot satisfy the definition of a taxi cab company, regardless of whose interpretation we apply.
Well, I mean, Classic Cab now is out of business. But if given the opportunity and a remedy that's appropriate, it could. And I would just, again...
Well, wait a minute. Hold on. I want to be sure I understand what you're saying. So Classic Cab Company is now out of business. Defunct in a sense.
Closed. It's closed down, but
not closed
waiting
down.
to...
But if given the chance, it could, you're saying, meet what it considers the proper definition of a taxi cab company. So what it should do then is file an application and show that. And then we can have, I mean, we'd be able to litigate that issue now, for example, if if there were not a mootness problem, and maybe we'll be persuaded there isn't a mootness problem. But you could nail that by establishing there's no mootness problem by actually showing that Classic Cab Company now, you know, there's nothing in the record that supports this, does have the ability to meet its own definition.
Well, I mean, it has its ability, the potential to do that, but it would need operating authority to get back into business.
The chicken and egg problem.
I mean, pardon?
Well, you're posing this as a chicken and egg problem, which came first.
If Classic Cab did not improperly have its license denied, it would have had operating authority. And then when it comes around to the time for the relevant time, which is December 15th, the time for turning in your application, by that time, Classic Cab would be in compliance. The relevant time in this case, there's no admission of lack of vehicles. Okay, I mean, the application was due December 15th, 2017. And this case was about the deficiency on that application. Whatever happened after that is not relevant to the application. If Classic Cab hadn't been unlawfully stripped of its operating authority, then it could rebuild itself. I mean, the court is saying, well, you can start your business. We shouldn't. We were wronged. That's our interpretation. We were wronged by DFHV's arbitrary actions and unlawful process, and that their actions cause, if there is any alleged mootness, it's by their actions. And so the remedy would be for appropriate relief would be to have operating authority and to operate for a reasonable period of time to come into have enough cabs to meet whatever definition that the court would decide. And there's an example with the specific requirements of 501 that relate to wheelchairs. Taxi cab companies have to have a certain percentage of their fleet must be with wheelchairs. And if by the time of the application, if you don't have the proper amount, they don't revoke your license. You have to submit a compliance plan and a time frame for when you can come into compliance and have enough wheelchair vehicles. That's a part of 501. That's an explicit requirement for something important, wheelchair service to the disabled. Not in
Well, of course, as Ms. Becerra pointed out, Mr. Lindsay was meeting with you, not with you personally, with Classic Cab on a monthly basis, giving them notice and the opportunity to come into compliance.
Judge, I would say that we objected to any of that's all hearsay. I mean, Mr. Lindsay's conversations, that's just inadmissible. I don't know how that's not. I mean, that's inadmissible hearsay. On that point, which I think is related to what you're saying, is that the DFHV is saying that Classic Cab could have done a merger. Classic Cab tried to do a merger and it had merged with Omnicab, and Classic Cab bought Omnicab during this case. It was pending, and DFHV disallowed it and would not allow the merger to go through because they said Classic
Sounds like
Cab.
that's hearsay.
But
all right. We've exceeded our time on this case. I'll ask my colleagues if they have any questions that they want to raise before I say that the case is submitted. Thank you both.
Thank you, Judge.
The case under advisement.
Thank you.
I'm calling the third case, C.A. Harrison Company versus Karen Evans. Okay, counsel for Harrison Company, Ms. Lurie.
Yes, good morning, Your Honor. Vanessa Carpenter Lurie. I would like to reserve 5 minutes for rebuttal if I can. Harrison Company filed this appeal from the judge's ruling that both claimed that, both found that the contract that he had or they had with Evanses was null and void, and also awarded contract damages. And we think that ruling was an error. The ruling was basically in favor of the counterclaim that was filed by the Evanses, and the Evanses filed a counterclaim alleging that there was a home improvement contract that had been entered into by Harrison, and that Harrison violated 14 DCMRA section 801 and DC code 283905 K1, all related to the home improvement statute. Our position is that Harrison's contract was not a home improvement contract and that Harrison did not perform any home improvement services as required by the plain language of both the regulation and the statute. And the court in ruling in favor of the evidence actually, in favor of the evidence, actually cited a different code of the DC, a different provision of the DC code. The court cited DC code section 283904, which is not the same code included in the complaint that the Evans has filed. So our position is that the development contract that Harrison signed was not a home improvement contract. It did not require Harrison to provide any home improvement services. And in fact, Harrison did not provide any repair work or do any work that is defined under the home improvement statute. And in fact, during cross-examination of appellee Karen Evans, she conceded that Harrison had not done any work.
He had not swung any hammers. That's true.
I'm sorry.
Is that your rule? It's a swinging hammer rule. You need to be on the ground. An employee of the company or the owner needs to swing a hammer on the construction site in order to do home improvement work.
I think that the contractor actually has to provide services with respect to the actual work, and I think that's what the regulation says.
What about general contracting work? Does that count?
Well, a general contractor is hired to generally they have a specific home improvement contract. So the general contractor, just like CSMI in this case, which was a general contractor, had a home improvement contract, and it was designated as such.
Okay, so you agree that the contract with CSMI was a home improvement contract, right?
It was.
And ultimately, your client, CA Harrison, performed all the tasks that were assigned to CSMI of project oversight, causing the work to be completed, contracting with subs. So in a sense, took over the contract from CSMI, or in a different sense, formed a new implied contract as the general contractor with the Evans. What's wrong with that?
Well, I don't agree, Your Honor, but so there are two things. There is whether Harrison took over the CSMI contract. I don't think that there was any allegation that they did. I think that the allegation was that Harrison did not notify, number one, the Evans that CSMI was no longer on the job. And basically Harrison proceeded to use the subs that CSMI had previously hired. And I think that because CSMI would have been in the position to actually do work on the job, Harrison did not do any work on the job, but continued to oversee the job as defined in its development management contract.
That's not true. I mean, what he says in his testimony is his job as development manager is to oversee the general contractor. The general contractor is gone. And what the Harrison contract also says is you won't be entering into any contracts with subs, which is something the general contractor could do. And that's exactly what Harrison goes on to do through the course of construction. So he's, I have questions about whether or not the Harrison contract itself is a home improvement contract, because he says it will cause the work to be performed, but he certainly performed the tasks that were otherwise envisioned for CSMI under that contract.
But Your Honor, then you go back to the development contract. There may be a claim then for breach of that contract, which is a different issue.
I mean, I agree that it's a different issue, but I don't see any of our cases adopting this sort of formalistic approach. If you look at the cover of the contract and whether or not it's labeled home improvement contract, it all looks very functional to me. Is this person taking on the functional role of making sure this work is getting completed, or are they just advisory to somebody else who's overseeing it? Like in Carr, our court said, I think 8 different times in that opinion, that there was a different general contractor and Carr had declined the role. And here, there was no other general contractor, and your client immediately assumed the role. So it looks very different on its facts than Carr.
Well, Your Honor, I think the other thing in Carr was that there was, and this court said that it didn't come under the statute, Carr actually performed work on the project. And
I think that hurts your case, because it tells me that the swinging hammer rule that you advocate for is not the rule. I mean, a swinging hammer is neither necessary nor sufficient to be a home improvement contract. If you are just, somebody who's performing menial tasks and not under the oversight of a general contractor, you might not be a home improvement contractor. But the general contractor is, and that's what Carr seems to say. What, am I misreading Carr?
I don't think you're misreading Carr. I think that my position is that my client is in a similar position to Carr. A home improvement contract, and I guess what the court is what the questions are leading to is if my client took over the CSM contract, which it did not. I think that the only thing you can say is that without CSMI there's no general contractor, and maybe he expanded the oversight, but not necessarily as a general contractor, although that was the way it was described.
But
Ms.
what about,
Fleury,
he's saying things like, oh, go ahead. He's saying things like, but he's saying things like he could complete the project in 30 to 45 days. It's, isn't that exactly the kind of thing a general contractor does?
Your Honor, I think that you can have overlap between being the project manager and being a general contractor. And I think that in his view, he was still being the development manager and overseeing that everything was being done in accordance with whatever the plans were. And that would have been his role also. He would have been making sure that the subs were doing their work in compliance with the architectural drawings and the project otherwise.
Ms. Lurie, we're not the trier of fact, of course. And so you've got to argue to us not only that it's arguable that your client was not the general contractor, but that the trial judge erred in finding that he assumed that role. And let me ask you a couple of questions about this. Didn't your client say more or less repeatedly that he had assumed the general contract? And in addition, didn't your client, is it not correct that your client did?
With, I think it was Victoria Baxter was the name of the contractor. I think then Baxter may have entered into contracts with some. I think he did arrange for maybe the roofer and some others, but I don't think there were 18 different contracts. I don't recall.
Well, maybe the number, maybe I misremember the number, but right. I do have the impression, and please tell me if I've got this wrong, that once Ms. Harrison took Mr. Harrison's, once CSMI walked off, Mr. Harrison, by his own admission, assumed their responsibilities and assumed their contract and hired subcontractors. And one has the sense that he's doing more than simply living up to the letter of the development management contract, which was basically designed to put him in the position of the owners so that the owners don't have to be, fussing around with this stuff.
Right. So as I said.
So to me, the question, to me, it's hard to see how the judge didn't have evidence to support the finding that Mr. Harrison was acting as a home improvement contractor.
Well, Your Honor, as I indicated, the statute basically addresses a home improvement contract to, and there was no home improvement contract between my client and the Evanses, and there was no agreement by my client to provide home improvement services, and that's our position with respect to it. In the Severn case, for instance, and I guess in all the cases, although the court seems to maybe think otherwise, it specifically talks about work performed, and if my client went beyond his responsibilities with respect to the developer's contract, then that's a different issue. But
let me just pin you down on because I can't quite tell which your position is. There's one thing that you might be saying, which is Harrison isn't doing home improvement work because it wasn't the general contractor and the trial court was wrong to find otherwise. Another thing you might be saying is, well, being a general contractor isn't going to cut it either. You've got to swing the hammer. Which of those two things is your position?
No, I'm not saying that, Your Honor. I'm saying that he had no home improvement contract with the Evanses. And so that's my.
Let's just assume for a second that an implied contract forms, whether it's an assumption of the CSMI contract or just by the course of performance and accepting payment, a new contract has been formed for general contracting services. Is that enough to be a home improvement contractor, or do you still need to swing the hammer? Which is
No, Your Honor, so that what you just said raised the second issue, because there are two things. Let's say he was the general contractor. Okay, there was no contract between him and the Evanses for that. You used their phrase implied contract, but there was no contract implied or otherwise for him to be the GC on that job. But there are two things that have to be complied with in order for the home improvement statute to be violated. And that's the second point, which is, let's say that he had a home improvement contract, which we say he didn't. Let's say that he took the role of the GC. He did not take any money for that. He was not paid for that. And that would have to be part of the basis upon which there's an order of violation and an order for disgorgement.
And that argument, and you say that because the money was passed along to subs. I mean, he certainly took money. I mean, that $170,000, there's a discrepancy about 177 or 207, but whatever. He certainly took a lot more money than what he was entitled to under the development management contract, which, by the way, he didn't do any development management once the general contractor was gone. But putting that aside, he took all that money. Is it by passing it along, that means he didn't accept payment? Is that your argument?
That's correct, Your Honor. That the money that he took from the bank was a part of the agreement with the bank as a part of the development contract, that the money would not go directly to the GC, it would not go directly to the subs, it would pass through him. And the court has indicated in both Carr and I think in recognizing the Schloss case and the Truitt-Miller case, that's okay, and that does not bring you within the home improvement statute. So that was a part of the development agreement, that the money from the bank is wired to him, and then he passes it through to the subs. And the evidence is all of that money, in fact, went to the subs.
Yeah, I mean, I understand the point. I just don't understand what's left of the regulation under your reading of it. I mean, general contractors are suddenly perfectly free to operate without a license. They can, so long as they pass through the money, they might, that's fine. You can only disgorge the amount they take in their fee. Is that right?
Your Honor, again, so if you forget that CMSI was gone, let's say CSMI was there. My client had a contract that was negotiated with the requirements of Sandy Spring Bank, that there be an entity that accepted the money and passed it through. CSMI was never to get the money under its home improvement contract. That money was to pass through. And again, the courts have accepted that. That's not a violation of the...
By the courts, you mean Schloss, right?
I'm sorry? By
the courts, you mean Schloss, I think.
Well, Carr also was that case. That was one of the issues, whether that situation came with...
It wasn't, because he definitely wasn't the general contractor. I mean, the court made a point to say it, like I said, I think 8 times.
But that's what I'm saying. The money that came through Harrison came through as a result of the development contract. There was no agreement that CSMI as a general contractor was going to get paid directly by the bank. The development contract was the basis upon which Sandy Spring passed the money through Harrison to the subs.
Sounds awfully formalistic, counsel. Like I said, I don't understand what's left of the regulations and how they can't be very easily circumvented if the interpretation we give to them is, so long as you organize your finances in the right way, you can be a general contractor without licensure. I mean, that's what it sounds like to me.
Ms. Laurie, can I ask you the following question? Suppose CSMI had remained in the case as general contractor. And at the end of the day, the work is done and the homeowners are dissatisfied. They feel that, you know, the subs weren't supervised properly, the bad job was done, that you didn't live up to your contract. I assume they could have sued CSMI for breach of its contract as a general contractor. Now, do you agree with that?
Yes.
And said the sub, you didn't monitor the subs, you didn't do all the things you were supposed to do, you picked bad people and so on and so forth. So what interests me is that here, CSMI walks out, and this is concealed, of course, from the owners for several months. And Mr. Harrison, by his own admission, assumes CSMI's responsibilities. Now, suppose this project had gone to completion and the Harrisons never learned about CSMI having departed the scene. And they discover, oh, you know, the guy who was actually overseeing all this and who by his own admission assumed the role of CSMI was Mr. Harrison. If they were dissatisfied with the quality of the work and thought the contract had been breached, do you think they could not have sued Mr. Harrison for breaching the contract, that the contractual duties that he assumed by his own admission?
I think they could sue him for breach of the development contract.
Well, but they could, what would that mean? Could they sue him for breaching for failing to do what a general contractor should have done under the circumstances?
No, I think they could have sued him for breach of the development contract.
But not for the shoddy performance of the subcontractors that I've hypothesized?
Well, no, I think that, because I think that if the agreement with respect to the development contract said, for instance, that he wasn't supposed to enter into any subcontracts directly, that's a breach of that contract. And I think as an extension of that, maybe they could include.
By breaching that contract, in that way, did he act as general contractor?
I think that he expanded what he was had agreed to do under the development contract.
I mean, if you asked him, he would say, yeah, I did. I acted like a general contractor. That's what I assumed the role of general contractor. That's what he said. You don't seem to agree that he did that, though.
Well, I mean, clearly, if there's no general contractor, which there was supposed to be a general contractor, there's no dispute about that on the job. I think his position is, I mean, he used the word general contractor, but I think he used it in the sense that he's going to continue to do what he was supposed to do, and there would not be this person that was supposed to be in between him and the subs.
But what do we make of the fact that he didn't tell the Evans?
The only thing I can say is that he testified that the Evans had complained about a lack of resources, and and this is his testimony, he thought he was saving them money or something to that extent by not going out and soliciting the services of another GC.
When he exceeded the scope of his development management contract and took on these additional duties, why do you think that didn't create an implied contract in fact, or maybe an implied contract in law, between him and the Evanses?
Well, I don't think you can have an implied contract unless both people are aware of the circumstances, and it's conceded that the Evans were not aware of it. And again, and I know, getting back to the money, he was not paid anything as a GC. He was not paid a dime as a GC. He didn't solicit any money, didn't put in a request for any money to be paid for that role.
If CSMI had remained in the case as the general contractor, would the roughly $200,000 that went to Mr. Harrison have been paid over to CSMI for distribution to the subcontractors?
I think the way it was designed is that the development management agreement was there as a buffer to make sure that the bank, number one, got proof of all of the invoices and all the expenditures on the project, which were provided by Mr. Harrison. They authorized the release of the money. And I think the very first one may have been all the money went to Harrison. Harrison did, I think, cut a check to CSMI, if I'm not mistaken, and then to the subs under the worksheet that had been provided to the bank. So the process was he would submit all the invoices from the subs, including any invoice that may have come from CSMI, any invoices for materials purchased. The bank got all of that information. The bank's inspector then went out and approved and said to the bank, yes, this work has been done. And so all that money was wired to Harrison to be paid out in accordance with the invoices that had been provided to the bank.
Yeah. I mean, the reason I ask is when I think of do I misunderstand how things work? When I think of a general contractor and subcontractors, I think of the subcontractors as basically being supervised and controlled and directed and paid by the general contractor. And if a party undertakes that role, such as Mr. Harrison, then that party is undertaking the role of the general contractor.
Well, that
just and that's different from saying, well, the money originally comes from the owner, and the owner is paying all those people, and the owner's not a general contractor. Sure, but the concept here was that Mr. Harrison started out being in the shoes of the owner and ended up being in the shoes of the general contractor.
Well, normally, I mean, in all circumstances, you don't have a person that's in Mr. Harrison's position as the development manager. The bank required this. They were not going to give the money directly to either the GC or the subs. They required that process by which the money would go through the development manager instead, and then be sent out, dispersed to the people that submitted valid invoices that have been approved based on the inspector's approval of the work.
So you could say Mr. Harrison also violated his duties to the bank.
Well, no, because all the records show that all the money that was dispersed by the bank to Harrison actually went to those subs in accordance with each draw schedule that was approved by the bank. I mean, that was documented to the penny. I mean, there was no violation of that requirement. And that's one of the issues that we have, that was a requirement under the development agreement. The bank's records are consistent with Mr. Harrison's records in terms of the draw schedule, the invoices, the wires to his bank, and then the payments out from his bank to the subs and the other vendors. They match to a penny. So that was a part of his original development agreement with the bank. And so there was, other than I think there were 3 payments from the bank of the $5,000 management fees. The original $5,000 management fee from the Evanses. There were no other payments, no other requests for payments from Harrison and Company.
Ms. Lurie, how do you, on another issue, how do you understand Judge Preglugo's, the legal theory behind the damages that Judge Preglugo awarded in addition to the disgorgement of all the money that Harrison received from
and again, I think that was legally in error. I think the case we cited, Bathroom Design, indicates, and Judge Preglugo even says that he found the contract to be void. I assume.
Is the answer to Judge Glickman's question that you understand them to be contractual damages? I think he just wants to, I mean,
Right.
Is that
Right.
how you understand?
Yes,
yeah,
I
I
want to know.
understand that he both ordered disgorgement and ordered contractual damages, even though he said the contract was null and void. Yes.
Do you understand that he ordered any damages for the violation that he found of the Consumer Protection Procedures Act.
No, I think that he considered the disgorgement the damages for the violation of the Consumer Protection Act. That's the way I understood his ruling.
Well, you don't need the DCPA for that. I mean, he could order disgorgement just on the basis of having no license. So, I mean, so I guess your answer is no. You think there were no damages attached to the
Well,
CPA.
he I think specifically declined to award treble damages. He denied the post judgment request for attorney's fees because of technical issues. So he limited the recovery to the disgorgement, which the home improvement statute provides for.
And what was wrong if the disgorgement was CPPA damages, in the judge's view, what was wrong with the judge's ordering contractual damages?
Because he ruled that the contract was null and void. He can't have a null and void contract and then award contract damages.
And is that true even if the performance of the contract caused consequential damages to the wronged party?
So to me, there's a little bit of confusion because I don't know if he's it's sort of a mix of, there was only one written contract between the Evanses and Harrison, and that was the development contract. And so I think that if the basis of he didn't find a breach of contract. I think he specifically said he was not finding a breach of contract. So I don't know how he came to those damages. It seemed to me he was adding it on to the CPPA violations. That's the way his ruling seemed to be worded.
Well, this is why I asked you what you thought his theory of awarding those damages was as a legal matter. Let me ask you the hypothetical question. Suppose we have a contract that is later determined to be indeed void, ab initio, null and void. And so to put the parties back in the position they were in before they ever entered into the contract, the court awards restitution, which is to say disgorgement of all monies paid under the contract. Now, suppose the court then says, but that doesn't quite do the trick in terms of fixing things, because when the party that committed the wrong in the case performed the contract, it didn't just sort of perform it badly or failed to perform. It wasn't just an illegal contract or in some way that has to be null and void. The party did some damage. It destroyed the plumbing in the house. It created a fire that did damage. You can imagine all sorts of consequential damages. And so now the innocent parties, instead of having a job that would cost them $200,000 or $300,000, which is what they contemplated and what they thought they would be paying the wrong party, they're going to have to pay $400,000 now because they have to fix up, because they not only have to get the job done, but they also have to repair all the harm done, sort of affirmative harm, done by the other party. Now, and so merely voiding the contract and ordering disgorgement doesn't really remedy the situation. Under those circumstances, does the law permit the judge to say, so I'm also awarding additional consequential damages for your bad performance of the contract and the harm you inflicted?
No, Your Honor, I don't think it does. I think that the provision in the home improvement statute allows the court to award treble damages if it so finds. And again, I think that was
The home improvement statute or the CPPA?
CPPA. It's so under the home improvement statute, I think that there are other damages that can be awarded. The court didn't do that, though. The court indicated that it was awarding these other damages, and the other issue with that is whether they were even proven. There was no evidence that there were any defects in the work that was completed. The bank's inspectors had approved all of that work. I think that there was in one category $60,000 awarded to Brown, but there was no matchup between the CSMI contract and the Brown contract. There was, I think, $87,000 left to complete the work that the bank's inspector had said was still due to be completed under the CSMI contract. And yet the court awarded $60,000 because there was a difference in the two contracts. And I think that was inappropriate. And again, I tried to say, and it's in our brief, the Bathroom Design Institute case, in which the court says that if you're going to disgorge, you can't also award damages. And in that case, the court reduced the amount of the award to the actual money that had been paid out under a home improvement contract.
Okay. We'll give you a few minutes for rebuttal. Let us hear from Mr. Long for the evidence.
Good morning, Your Honors. Victor Long on behalf of the appellees, Karen Evans and Charles Evans. May it please the court, I believe the matter has been briefed well, and I do not want to cover any of that again, but I would like to make 2 points. One is an observation about the development of the law in this area of consumer protection. I believe that a discussion of 3 seminal cases will show that under the intentional misconduct proven in this case, I think that's what we have is intentional misconduct, that the remedy fashioned by the court is fully consistent with the case law and the applicable regulations. The second concern I'd like to address is, and I think the court's already made reference to it, is the court's calculation of the money that Harrison received, which must be disgorged, how he arrived at that decision. Just looking at this, get the case law broadly in this area.
But before you, rather than doing a broad view, could you answer the question that Judge Glickman asked to Ms. Laurie, which is, what do you understand the basis for the award of damages to be beyond disgorgement?
I think that it was a remedy that was fashioned by the court that was in accordance with the case law in this area, and that it sounds in contract, but that also it could be viewed as a valid remedy under the Consumer Product Safety.
So let me just stop you there, because there's actually a lot in that answer. But we would not be able to affirm an award of damages under the CPPA if that is not, in fact, the theory that the trial court espoused for damages. So am I correct that I understand you, like Ms. Laurie, to understand the money above disgorgement to have been awarded in contract?
I think that the decision as it's written, if you look at the language, and I've gone over it several times.
So have I.
But obviously, that it's somewhat unclear. It is what I would say is how the court moves from the disgorgement language to awarding consequential damages based on what appears to be, the best I can discern from the decision, based upon a violation of the development agreement. In other words, the Evans wouldn't have suffered these damages if the development agreement had been properly administered. And that's where it goes off the rails. I hope I've answered that question.
Do you understand the court's initial ruling to be that the development agreement itself is null and void because it was a home improvement contract?
I believe the best the best answer to that is that where there is an agreement to perform home improvement and the contractor is not licensed, then the contractor must return all of the funds.
Right, and I was just trying to tee up Ms. Laurie's point that once a contract is null and void, you usually aren't awarded, disgorgement, sure, but consequential damages to fulfill the contract that is null and void in the first place, I don't think is an appropriate remedy, but you're free to correct me.
Well, so here we have a home improvement contract and we have a home development contract or a developer's contract. And so when he assumes the duties of the general contractor, he has to disgorge that, but it doesn't relieve him of his duty as a development contractor.
So you are abandoning an argument that the development contract itself is a home improvement contract that the trial court found null and void. I have to say, it's not so clear to me that you've made that argument. It's not so clear to me that that's consistent with the trial court's ruling, but let me understand. You don't think the development contract was declared null and void. You think something else, be it an assumption of the CSMI contract or an implied contract, was home improvement contract that was declared null and void.
Yeah, actually, it takes us back to the argument of the question of, do you have to have, what does the document have to say? Because a lot of the case laws say you don't even really need a written agreement. You just have to, it goes back to the purpose of the statute, that you have to perform home improvement work. And so the disgorgement is based on the fact that he performed home improvement work and he was unlicensed at the time. And that's what triggers the disgorgement. But in addition, there was a development contractor in this case. And Mr. Harrison had duties under that contract, which he didn't fulfill, and which also caused damages that I believe were fairly well supported by, not fairly well, they were extremely supported by
I guess I want to press you on. So no matter what the theory is, be it in contract or the CPPA, in what sense was your client damaged beyond the, we'll call it, again, it's 177 or 207, there's a dispute about that. In what sense was your client damaged beyond the $200,000 that they've already gotten back in disgorged funds? Because that covered everything. That covered everything that needed to happen to, pay for the rent and recover the lost tile that they say was stolen and the HVAC and to complete the work and pay Brown off. That's all. The $200,000 was more than enough to do all of that. So once you account for the disgorged funds, in what sense was your client damaged more than that?
I think that's not what the record shows. I think that the amount of money, and I can point to that in the record, the $207,000 was just the money that was received by Harrison.
No, I understand that. I think my point to you is, after getting that, they get disgorged the $200,000 and your clients get a windfall of about $200,000 worth of work on their house. Maybe they weren't totally pleased with all of it, but they then were able to complete the scope of the work and a contract that they knew was going to cost $300,000 for considerably less than that. It seems like a windfall to me. So I want you to see if you can convince me otherwise.
Let me give that a try, because that's not exactly what I believe the evidence showed. In other words, what happens is that the Evans, once they happen to drop by the property to see what's going on, and they've realized now that they've got a big problems that they didn't have. And so it's a very careful analysis of those additional damages, and they're set forth in a chart that was presented. And these were all things that they wouldn't have had to pay for otherwise. For example,
but it also didn't discount the disgorged funds in that chart, right? It doesn't discount. It doesn't give CA Harrison any credit for the work that they've performed now without pay owing to the disgorged funds.
Well, well, actually, he's received money, including the CMSI money, as a development contractor, and that $207,000. That would have gone to, if this had been done properly, all of those funds would have been distributed, and CMSI would have been paid appropriately, because it includes deposits that were paid before the project even began. So these are all, goes back to the point of, if this had happened and there had been a general contractor on the job, the Evans could have said, hey, wait a minute, you flooded our property. You owe us money. You've got insurance. You're a licensed general contractor, and in the District of Columbia, you have to have insurance for these sorts of things.
I think my point is those, I'll grant you that there were some damages, there was some tile theft that's accounted for. But I think my point is your client was also, once you account for the disgorged funds, your client was also considerably enriched. And I know unjust enrichment is not a theory upon which CA Harrison can recover once they're unlicensed, but it does strike me as a theory upon which they could offset your claim to damages. And in this case, they finished the home project inarguably for less money once you discount the disgorged funds than had CA Harrison never touched the place. So it seems that to be putting them in a better position than they were just absent voiding the contract. And I haven't, I guess, heard why I'm wrong to think that.
Well, what I would point to is the Severn decision. And I think Judge Farrell's decision-making there was quite apt, because basically what the court is deciding is that we're going to reject all of these arguments about unjust enrichment, quantum merit, and go to the purpose of the statute, which is harsh. It's a harsh situation for people who decide to engage in this unscrupulous, really, form of behavior. But despite all of those things, and then, and the court says, once again, we confront the situation of a home improvement contractor who accepts payment. And once again, we're going to reject all of those equitable arguments that have been made over the years to try to make this rule so harsh. And I think that we're bound by Severn. And if we
but again, that was a question of whether or not Severn could get their money for the work that they had done. And that question's not on the table here. The question is only, once the money is disgorged, the question that I'm putting to you, once the money is disgorged, do you get additional damages in contract that do considerably more than make your client whole? And let me just give you an example to try to put a point on it. Let's say I am an unlicensed, I've got no expertise in building homes, but I tell you I'll build you a home for $50,000. And we sign a home improvement contract, and I take the money and run. I understand the argument that I get disgorged to that $50,000. But let's say you then find another contractor who looks at the scope of what I promised and said, there's no way I can do that for $50,000. In fact, it's a $500,000 job. Am I also on the hook for fulfilling the contractual promises do I not only get disgorged to the $50,000, but I also have to pay the $500,000 to have it done by somebody the right way? Because that seems to be what the trial court did here.
Well, I think that it certainly has that appearance, but I would also state that there is some unclarity between what's being awarded under the DCCPA and the contract theory. Our position is that, and I understand what you're saying. I understand what you're saying, how there could be some double counting. But I also think that if you look at the purpose of the statute, as well as the authority that the court has under the DCCPA to remedy these sort of problems, that the remedy that the court fashioned was totally appropriate given the nature of the offense. And so
under the CPPA you're arguing now, and just to get a quick question in, if that's right, say I agree with you on that, wouldn't we need to remand for an articulation of a theory like that by the trial court to see if that is in fact, I mean, I agree with you, its ruling is quite unclear. I mean, it seems the best case scenario for you is that we'd have to remand it for some articulation of a theory of damages beyond the disgorgement.
Your Honor, I'd have to agree with you that the decision in that regard is not as clear as it could be.
Well, one concern I have about that is that you haven't cross-appealed. In other words, you haven't, for example, challenged the trial judge's refusal to grant treble damages, or even the semi-nominal damages of $1,500 per whatever we decide is the incident. And I sort of wonder whether not having cross-appealed, that limits the kind of scope of any remand that you could be entitled to. It is troublesome that we don't have a clear idea of what the judge's theory was, or whether it's a correct legal theory for awarding some of the damages. But something I wonder about, you did mention that there were, in a sense, two contracts here. And I wonder how far that can push, particularly since it's funny when we say that the unlicensed work, that any contractual obligation for the unlicensed general contractor work is null and void. And the reason I say that's funny is because if the work had been performed, had been completed, and if the unlicensed general contractor had not asked for any money prior to the completion, that contract, as I understand it, would not be null and void. It would be a valid contract, and the owner would be obligated to pay at that point, after it's completed, assuming it was performed correctly, the contract price. And if the contractor damaged the property in some way or created, other costs for the owner in some way, those might be recoverable in a breach of contract action. It's only the seeking or getting of interim payments that triggers the forfeiture. And it makes me wonder whether we're right, although our cases have done it, to call this a null and void contract. As a practical matter, it's going to have to be that way because the general contractor is not going to continue doing work for nothing. And so the contract really is going to be at an end. But in theory, it doesn't have to be. But your argument seemed to me to be that the disgorgement relates to the implied contract to be a general contractor.
Correct.
And the damages relate to the breach of the development management agreement, which you sort of view as separate. Now, I don't know if the judge articulated it that way or thought of it that way, to be honest.
It's my opinion that that's that based on the language of the opinion, that that's exactly what the judge did.
How do you respond to Ms. Lurie's argument that there's no implied contract here, that for there to be an implied contract, the parties on both sides have to understand that there is one and the in some sense. And the owners here, the Evans here, never knew that until it was too late, that Mr. Harrison was assuming the contract of CSMI.
I think it's actually based on the code and the regulations that were developed by the code, that it becomes a contract as a matter of law. It's any agreement to perform work that triggers the regulations. I mean, you don't have to,
Ms. Lurie would say there was no agreement. Ms. Lurie would say that's exactly right. When there's an agreement by an unlicensed entity to perform general contract work or home improvement work. But here there wasn't an agreement.
No, and I disagree with that.
He did it on his own.
It's because as soon as he says, I will complete the work, I am taking responsibility for completion of the work, then by statute, it becomes, and the regulations, it becomes a home improvement contract. And that's
but the contract with Harrison says that. The development contract that you're saying maybe wasn't void. It says part of the responsibilities under clause 3 were to cause the work to be completed. Are you sure you don't want that to be a home improvement contract?
And
I mean, are you sure that's what the trial court found?
And the judge and Judge Puig-Lugo, I believe, ruled that this gentleman intentionally stepped into the role of a home improvement contractor, and he did it surreptitiously and with the intent to defraud.
You know, I just have one question, if I could sneak it in. Do you want to give any response to the, $25,000 that there's a calculation error in the $207,000?
Yeah, if I may.
30,000 of it went, 25 went to CSMI, 5,000 went to the architect directly.
Okay, so in that regard, I believe it's interesting in the appellant's brief that they go right to the progress payments rather than to address what was a very specific discussion, several discussions over how we reached the $207,000. And I think the best thing for me to do at this point is just to direct you to the specific places in the appendix where that occurred so that we could see exactly what's going on here. The court at appendix page 296 in discussing with in closing argument the defendant's chart of damages they go on for about 4 pages discussing that very issue, and it's in part based on a calculation of the amounts that were paid in advance by the Evans, and those checks are at appendix page 873. And lastly, and I think perhaps most importantly, there is a document in the Sandy Spring Bank records, and it's a appendix page 961, and it's called the application and certification for payment. And there's a line on it for total 6, and this is a document signed under oath by Mr. Harrison that says the total earned is exactly that same number, $207,973.08. So that's where there's sufficient evidence in the record to reach that conclusion, as opposed to simply looking at the amount of the bank draws. There was a lot more money exchanged, and there was sufficient evidence in the record to support the court's finding.
Again, just to look at, and I'm sorry, just to look at 961 real quick. Is there any indication that the $30,000 that's paid to CSMI and the architect is discounted from that total? Or
I think it's included in the total, in that total. Because I think that's the bank took that into consideration.
okay.
Mr. Long, one follow-up question, if I could. Appellant argues that there were some expenses that should not have been disgorged because they are carved out of the general rule of disgorgement, air conditioning, plumbing, certain categories like that. Do you have any response to that?
I do, and that was the point I was going to make initially, looking at the development of the law in this area. And so we have a case like the Truitt case where the court does exactly what Your Honor is suggesting. It says, well, now wait a minute, what about the money that went to the licensed plumbers? And they remand on that basis. And then we once we move to the Carr case, and the court, is careful to say, now wait a minute, this is just a development contractor. It's consulting. They don't have a development agreement, and so we want to carve out this exception for developers. By the time we get to Severn, and under the facts of this case, what we have is, a gentleman who's actually gone to law school, a gentleman who's actually taken business accounting, who has taken charge of the books. And, our point is that the court didn't rely on our expert accountant, but the point of that testimony was that this is a person who can cook the books. We really don't know where this money went. We really don't have a paper trail as to whether the money he's receiving is actually going to certain invoices. And so it's now that we've created this developer loophole, if we allow unscrupulous home improvement contractors to take out all the accounting, it shouldn't be the consumer's burden to figure out where the money went, especially under the circumstances of this case, where you have a rather sophisticated person who apparently has found a niche into doing this sort of thing. And so the evidence in the record was that the TMSI probably never intended to perform under this, and he was going to fool the bank. Realize what the bank did. Once they found out what happened, they were furious, and then they required a general contractor who had insurance to come in. This is going to wreak havoc in the home improvement.
Just so I make sure I understand your answer to Judge Glickman's question. I heard two sorts of answers, and I want to see which or both are your answer. One was sort of this: Truitt has been implicitly rejected by later case law in Carr and Severn. And the other one was, look, there's just not a factual record developed as to how much of this went to the subcontractors, and it was on them to do it under the case law. Which of those is your answer?
Both.
All right. I think one of them's good and one of them's bad.
I appreciate your response, Your Honor.
Mr. Long, thank you. Let us hear from Ms. Lurie now in rebuttal. Give you 5 minutes. I think you're still on mute.
Can you hear me now?
Yes.
Okay, so it is not accurate that evidence was not provided with respect to the disbursement of the money. Part of the evidence and part of the appendix to this court are actual counsel checks, bank statements that back up exactly what was submitted to Sandy Spring Bank. It is consistent with what Sandy Spring Bank produced. They're counsel checks. You can't say that the money was not dispersed in accordance with the draws that were approved.
On the more particular question of whether and what amount was dispersed to licensed contractors that fit with the exemption that you argue for, HVAC specialists, electricians, where is there an accounting of that anywhere in the record?
So that was part of actually the trial testimony as to who had licenses, who had or not. I mean, the court didn't even address that issue. It just simply said all of the money is lumped in. It was clear that there were licensed contractors, and
Yeah,
that
but how could the court, well, once the evidence is closed, how could the court have addressed the issue in anything other than a purely speculative way if there's no accounting for what percentage of the money that you received went to those specialists?
because, Your Honor, I think one of the, and unfortunately we didn't provide it to this court, but those issues came up during the trial, and some of the licenses were actually provided as evidence in the trial.
I mean, this is not an adversarial question. It's really, maybe you can help yourself out here. Can you do you have a number of dollars that you think went to specialists that should be exempted? And if you don't have that number off the top of your head, what can I look at to say the trial court could have figured that number out in some reasonably specific way without just wildly speculating based on the evidence that was before it?
Your Honor, I don't, as we sit here today, know exactly what that number was. I know that with the ledger accounting that had been provided by Harrison Company, it identified each of the people that got money. And part of the trial evidence was which of the people actually had licenses that provided the work. I believe, I believe that, again, the trial court had that information in making this determination. In addition, I think the Evans conceded that CSMI had a license. That was one of the due diligence efforts that they undertook when they hired CSMI, and they're trying to lump in that initial payment that was paid to CSMI. Part of the initial money, and this is how they get up to the 2007. The 172 is the amount that the bank actually wired after the project started. And so the additional money is the initial $5,000 development fee, the $20-some thousand that went to CSMI, and then the money that went to the architect who was licensed. He submitted the drawings. So the trial court had that information and did not take that into consideration in making this ruling. Obviously, we still disagree that that money should be disgorged because we believe it was paid under the development contract and not under any thought that they were giving that money to a general contractor.
Okay, I take it that you have nothing else you want to say in rebuttal?
No, Your Honor. I think that is it. I think that Mr. Long indicated that the Carr case specifically recognized that you could have a development management agreement and it not come within the home improvement contract. So the court would basically have to determine that the arrangement that Harrison Company had with Sandy Spring Bank and Evanses with respect to how the money was going to be passed through Harrison to the subs was in fact in violation of the home improvement statute, and I believe it was not.
Okay. Counsel, thank you very much. The case is submitted.
Thank you, Your Honor.
This honorable court is now adjourned.